2 days ago, the federal government did something it has almost never done before. It sued two of its own states over their gun laws. Not a gun rights group, not the NRA, the United States Department of Justice, the same department that is supposed to enforce federal law, walked into federal court and filed lawsuits against Virginia and California, arguing that both states are violating the constitutional rights of their own citizens. Virginia banned the AR-15, California banned the Glock, and the federal government just said, "Not on our watch." This is not a small story. This is the federal government declaring that the most popular rifle in America and the most popular handgun in America cannot legally be banned by any state. And it is happening at the exact same moment that the Supreme Court has agreed to take up the assault weapons ban question once and for all. The Second Amendment battle that has been building for years just escalated to a level nobody has seen before. Here is everything you need to know. Let's start with Virginia, because that story has a twist most people do not know about. Earlier this year, Virginia Governor Abigail Spanberger signed Senate Bill 749 into law. Starting July 1, 2026, it became illegal to buy, sell, or transfer a semi-automatic centerfire rifle with certain features in Virginia. That includes pistol grips, folding stocks, and the ability to accept a detachable magazine. In plain language, the AR-15 is banned in Virginia. So are most modern sporting rifles. The law also bans magazines that hold more than 15 rounds. The standard magazine for most popular rifles holds 30. Here is the twist. By the time the Department of Justice filed its lawsuit on July 1, the Virginia ban had already been blocked by a state court judge. Gun rights groups, the NRA, the Firearms Policy Coalition, and the Second Amendment Foundation had already filed their own lawsuits and won a preliminary injunction. The ban was stopped before it could take effect. So why did the DOJ sue anyway? Because this fight is not just about Virginia. The federal government is not trying to save Virginia gun owners from a law that is already blocked. It is trying to set a legal precedent that kills assault weapons bans everywhere. Virginia is the vehicle. The destination is the Supreme Court. The DOJ's complaint says directly that Virginia's law cannot survive the Bruin test, the standard the Supreme Court set in 2022 requiring gun laws to be consistent with America's historical tradition of firearm regulation. The complaint also argues that the law must be struck down because the covered rifles are in common use by law-abiding Americans for lawful purposes. And it asks a federal court to overturn the Fourth Circuit Court of Appeals precedent that has been used to uphold assault weapons bans across the region for years. That last part is the most significant. The Fourth Circuit covers Virginia, Maryland, North Carolina, South Carolina, and West Virginia. A ruling against Virginia in federal court could blow up assault weapons bans across the entire region. What California did, and why it is even more complex, the California lawsuit is actually two lawsuits in one, and the second part affects gun owners across the entire country in ways that most coverage is not explaining. Part 1 is the Glock ban. Governor Gavin Newsom signed a law in June 2026 that bans the retail sale of handguns with a cruciform trigger bar, a design component that is a defining feature of Glocks and has been adopted by dozens of other manufacturers since Glock's patent expired. The law does not name Glock specifically, but it effectively bans Glock and every handgun built on similar trigger technology. The DOJ's lawsuit calls it exactly what it is, a Glock ban, and argues that California cannot ban the most popular handgun in America. Part 2 is the California handgun roster. This one has been around for years and most people outside California have never heard of it. California maintains a list of handguns that are approved for sale in the state. If a gun is not on the list, it cannot be sold to civilians in California. To get on the list, manufacturers have to pay fees, submit to testing, and comply with a set of requirements that gets stricter over time. The result is that the roster shrinks every year. Guns get dropped from the list and almost none get added. California gun owners today can legally buy from a list of handguns that is a fraction of what is available to gun owners in other states. Modern handguns with features that have become industry standards, including the Glock, cannot be sold there. The DOJ's lawsuit argues that the roster is unconstitutional and must be abolished. If the federal court agrees, California gun stores would be able to sell the same handguns available everywhere else in the country for the first time in decades. Maryland and Massachusetts have similar roster systems. A ruling against California could blow up those rosters too. The pattern behind the lawsuits here is something important that ties all of this together. These two lawsuits are not isolated actions. They are the sixth and seventh gun-related lawsuits filed by this Justice Department. The Civil Rights Division, the part of DOJ that normally enforces civil rights laws against discrimination, has set up a dedicated Second Amendment section. It is treating gun owners as a protected class whose constitutional rights are being violated by state governments. That is a significant philosophical shift in how the federal government views its role in gun law enforcement. Normally, the DOJ enforces gun laws. It prosecutes people for violating them. What it is doing now is the opposite, suing states for passing them. Assistant Attorney General Harmeet Dillon warned Virginia publicly in April when the bill was signed, "See you in court." She warned California in June and gave the state 1 week to enter pre-lawsuit settlement talks. California's Attorney General refused. The DOJ filed suit 2 days later. This is not improvised. This is a strategy. Now here is where everything starts to connect. On Tuesday, June 30th, 1 day before the DOJ filed these lawsuits, the Supreme Court announced it would hear 2 cases challenging assault weapons bans in its next term. One case involves an ordinance in Cook County, Illinois. The other involves a Connecticut law. Legal experts who have reviewed the cases told reporters that the laws are likely to be struck down. Based on the Bruin framework and the direction the court has been moving, the expectation is that the Supreme Court will rule that assault weapons bans violate the Second Amendment. If that happens, every assault weapons ban in the country falls. Virginia's law, California's law, Maryland's law, Illinois law, Connecticut, New Jersey, Massachusetts, Hawaii, all of them, gone. That is the endgame the DOJ lawsuits are building toward. The federal cases against Virginia and California create legal pressure at the circuit court level. The Supreme Court cases create legal pressure at the top. They are working the problem from both ends simultaneously. The question is not if the Supreme Court will hear a major Second Amendment case on assault weapons. It already agreed to. The question is what it will say when it does. And based on what it has said in every major gun case since 2008, the direction seems clear. What this means for you if you are a gun owner in any of the 11 states that currently have assault weapons bans, or in any state considering one, here is the practical picture. The Virginia ban is currently blocked by a state court injunction. A federal injunction from the DOJ lawsuit could add a second layer of protection. Virginia gun stores can still sell you an AR-15 for now. In California, the Glock ban took effect on July 1st. The DOJ lawsuit seeks a court order blocking enforcement, but that has not been granted yet. If you are in California, the Glock ban is currently in effect while the legal challenge works through the courts. The Supreme Court's assault weapons cases will be argued sometime in the fall or winter of the 2026 to 2027 term, with a ruling likely in the spring or summer of 2027. That is when this entire issue gets decided, one way or the other. Between now and then, the legal battles in Virginia, California, Illinois, and Connecticut are all building the evidentiary record that the Supreme Court will use to make its decision. Every ruling, every injunction, every argument filed in federal court right now is feeding into the case that will eventually end with a Supreme Court opinion that either upholds or strikes down every assault weapons ban in America. We are somewhere between the beginning of the end and the end of the beginning on this issue. The fights happening right now in federal courtrooms across the country will determine whether the AR-15 and the Glock remain legal for you to buy in every state, or whether more states can follow Virginia and California down the path of banning the most popular firearms in America. If this video helped you understand what is happening and why it matters, drop a comment below. Are you in Virginia or California? Are you watching this from a state that might be next? I want to hear from you. Hit like if this was useful, subscribe and ring the bell so you do not miss the next video. The Supreme Court assault weapons cases are going to be the biggest Second Amendment story of 2027, and we will be covering every development as it happens. See you in the next one.